But we want to get started tonight. We are so excited. We have Ivette Kuyateh here. She is amazing. She's an attorney who's going to speak with us about special needs trust tonight. Yvette is a seasoned financial educator and passionate about empowering others with tools and estate planning strategies to grow and preserve their wealth. Yvette is also a former prosecutor, experienced litigator, and a zealous advocate, having handled hundreds of trials. Often she's referred to as the Wonder Woman, both in and out of the courtroom, for her passion for standing strong as a voice for the voiceless and advocating for the rights of others in her community. And don't we just adore that? That is so good. It fits in so well with our families and all the needs that we have here. So, Yvette, welcome. We're so excited to have you here.
Thank you so much. It is such an honor to be here with all of you tonight. Quick visual check. Can you see the screen? Okay, I had to switch my screens.
Yes,
So,
we can.
okay,
Yeah, we're
great.
good.
Awesome. So yes, I'm really excited. Thank you guys for the work you do, and for having me on. It's such a special community, and I want to acknowledge, welcome everybody that's here for showing up. I know our lives are so busy. There's 1,000 things coming at us. And you may be listening in, you may be catching this on replay, whatever the case may be. I just want to acknowledge, you for showing up, because a lot of times caregivers will put off our own needs and instead of to that week so we can care of the needs of our loved ones. And so I just want to acknowledge that. And I also want to acknowledge that this is not the most fun topic to think about when it comes to planning for what happens when I'm no longer here, right? This webinar specifically is for parents of children with special needs. And as a parent myself, I mean, that's like the last thing I want to think about. But we're not here to talk about worst case scenarios. I want you to take a deep breath, right? We're just here to give you peace of mind and some next steps. But I do want to acknowledge the heaviness of this topic and the emotional weight that all the caregivers carry. So thank you for being here. All right. So if you've ever wondered or this thought crossed in your mind, what happens if something happens to me? What happens to my child, right? What will my child lose benefits if they inherit money? Am I doing enough? Is there something else that I can do, right? Then you're in the right place. You're listening to the right person. You're in the right community. You're right here, right now. So our goal tonight is to help you be proactive and remind you that no matter where you are in the journey, you're not behind. Wherever you are, you're doing enough. And we're just going to give you some tips on some other things to consider. Okay. So I love to call this series my Planning with Love. All my parents that I sit with plan with love. But for most of the families that I sit with, right, we're planning for my child's going to turn 18, go to college, get a job, and then a master's, and yada, yada, yada. But for families with children of special needs or medically fragile children, that's very often not the case. We're planning for beyond you caring for them, who else would step in and care for them? Because the reality is those kiddos have a different trajectory by the nature of some of the limitations. And so we have to plan for that. It's making sure that the planning isn't based in fear, it's based on reality, but also in love, protection, and giving you that peace of mind. Most families that I sit with that have done this, they tell me, I've been thinking about doing this for 5, 10 plus years. Even now, some children are adults, and the parents say, I've been wanting to, I just don't know where to start. I didn't know what to do, what steps to take. Um, so I'm glad you're here. So in this webinar, we're going to talk about, you know, understanding, of course, special needs trusts, key benefits to planning, and the importance of planning. But we'll go a little bit deeper and talk about why money can unintentionally harm their benefits, right? We'll talk about the different types of special needs trusts, some California specific things to worry about, common mistakes that I see, and like Kristen said, some Q&As at the end. So if you have a question, you can save it, you can put it in the chat, or if you want to, you can text it in to me. You want to put your business out there, you can text it into me. The number's on the screen right next to my name. All right, so understanding public benefit limits. Let's talk about the hidden risk no one talks about. So why special needs trusts? Why do you probably have heard this. This is probably nothing new to most of you, but I'm gonna just clarify so we all have the same level of understanding, right? Um, when you have a disability, there are different programs that lawmakers have put in place in order to help assist you and your caregivers be able to have a holistic life and access to services. Some of those programs are SSI, those are financial assistance, Medi-Cal, medical assistance. But both of those programs are means tested, means that you have to have a very low threshold, $2,000 in assets or less. And that means that if you get an inheritance or a gift or you're in an accident, you get a settlement from that, it can count towards that means test. And even a small benefit or a small inheritance, grandpa wanting to give you a $10,000 for college or whatnot, that could put you over. And the results of that could be devastating for some families that depend on these different disability benefits. So that's why planning is very, very important and being aware. What happens when we fail to plan or we have inadequate planning, right? Well, if a child receives the money in their hand or an adult receives the money in their hand and they're receiving SSI or Medi-Cal, it'll stop or pause their income and their medical benefits. And the result of that could be, as you can imagine, very stressful. While the family scrambles to all of a sudden pull resources for that financial instability, but most of the time we see it in medical bills or medical needs that go unmet. And this is preventable. This doesn't have to happen. So that's why people like this community who know people like me are saying, all right, let's take 1 hour out of a crazy Monday evening to make sure that we get this information to folks so that they know. Because when people know, when they're educated about a topic, when they understand, they're not in a reactive state, they're in a proactive state. And that's where I want you all to be. Not reactive, not in fear, proactive, knowing, okay, these are scenarios that I want to prevent. I want to help my family avoid. So what does a special needs trust do? We'll call it S&T for short, right? It's a trust fund. It holds money for your child. The trust owns the money, not your child. The trustee has the keys. Think of it like a theoretical safe deposit box. They have the key, not your child, and they manage the funds. Because the money doesn't go directly into that child's hands, it preserves their SSI and Medi-Cal. It allows the trust to hold the money. It allows the trustee to access the money, thereby making sure that there's financial support to supplement whatever SSI does not cover. Their quality of life isn't interrupted. We're building out long-term financial security for them in the meantime. And that, yes, that depends on the resources that you have. I have some ideas about how to do that because I am an attorney, but also a financial educator. So I wear both hats when I'm working with my families. So that in simple terms, right, these trusts supplement, they're not replacing the benefits, and they're there and they're able to grow long term as the needs of your child need to be met. Again, we're not planning for 18 and you're leaving the house. We're planning for who's going to care for my child when I'm gone. That's a very different scenario and a very different line than most families. So what can a SNT pay for, right? Again, think of SNTs for supplementing. So they can pay for therapies that are not covered by insurance. They can pay for education, tutoring, transportation, technology and devices. There's a lot of new technology coming around. AI, I think, is going to revolutionize a lot of the technology available to this demographic, to these families. It could pay for camps, for companions to go with them to camp, to travel, and all kinds of other enrichment and comfort items. Again, quality of life preserved and supplemented so that they can have it if the special needs trust is drafted correctly, because you want to avoid penalties. Okay, so highlight that. If drafted correctly. This is why this is a very specialized, hyper-technical area of law. Not a lot of attorneys are comfortable doing it because of the hyper-technicality that's required, the understanding, the depth of what's required when you're putting these together. So again, it can work if it's drafted correctly. Okay. What an S&T doesn't do. Okay. So it is not allowed for direct inheritance. Again, it prevents your child from inheriting in their hand. We want them to have their inheritance. We just want to make sure it's funneled through so that it doesn't kick them off of their benefits. And it does not equal just this big bucket of cash that the trustee can go in there and just spend unlimited, right? No, it doesn't remove their independence. It makes sure, in fact, that they're supported with dignity. The trustee does have to abide by fiduciary provisions and limitations to controlling a special needs trust. Okay. So let's compare the different types of special needs trusts. You may have heard of them before. I'm going to hopefully help clarify the differences between these two. Okay, so there's two types, first party and third party. There's also pooled special needs trust. I'm going to save that for a few more slides down the road. I want you to focus on first party versus third party. Both have the same goal, which is designated to protect the benefit eligibility of that beneficiary, aka your child. But they're different. A first party special needs trust, we use that when the child has their own money. Maybe, again, they were involved in a lawsuit. They got a chunk of money out of a settlement, something like that. Right. With first party special needs trust, it's funded with their own assets. They fund it, first party. The issue with first party is that there is a payback clause that's required to be put into the trust, Medi-Cal payback clause. And that payback clause says the state can reclaim what it spent on your child after your child passes away. So after that beneficiary dies, it isn't someone else doesn't inherit whatever's left. Medi-Cal gets to take back. If I put out $1 million in healthcare over the years and $1 million is left, I get it, as in the state of California gets it. These are typically created when we have a minor, again, that's under 18, but they can't manage it. They got some sort of settlement, cash settlement for something. Okay. Adults can have a special needs trust too, but after age of 65, they have to do it before the age of 65, sorry, if they want to be exempt for Medicaid purposes. Again, we're focusing on children right now. I just want you to kind of understand the difference between that was first party special needs trust. Now we're going to third party special needs trust. So third party is exactly that. It's third party. It's funded by relatives, parents, grandma, grandpa, their money. Okay, they fund it either upfront by creating an investment account or setting up a account now, or at their death, designating a percentage or an amount for that specific child's special needs designated third-party trust that's already established. There's no age limit to this one. This can be created from birth to an adult of any age. This is the most commonly used for families because there's no Medi-Cal payback requirement, no Medi-Cal payment clause. And that's the biggest advantage of this one for the families. So just to kind of recap, right? The one we're focusing on majority of time is third-party special needs trusts. It safeguards the child's assets. It's flexible. It allows the funds to be used for the purposes, some of the ones I just described in the previous slide, to enrich, supplement, enhance their life. It can be flexible as the life changes. And at the end, there's no Medi-Cal payback. Just great. Okay. What are some of the California specific benefits that we're protecting with of trusts like these? We talked about that already. So there's SSI, the income they get monthly, Medi-Cal, medical housing. Some of these families rely on affordable housing, in-home supportive services. And of course, there's the regional centers, which are specific to them. But California has a pretty strong wraparound services, but they do have strict rules. And so it's good to know what's available, but also knowing that there are strict rules. And I'll pause here just to share just a little bit from my family story. I first learned about all of this when my nephew was dropped off to my stepdad at the age of about 5 because his mom she couldn't take it anymore as a caregiver. We had seen the early signs of him having going to require some special needs, and she just was overwhelmed and she couldn't handle it. It was a very rural area back then where we lived, and I can't speak enough about the regional centers. Not everybody has access to them. My nephew definitely didn't have access. San Diego, we're so lucky. in other areas of the state are so lucky, but some parts of the state, they don't have that access, so the families are not aware of all of these resources that could be available. I think that would have made a difference to my nephew and his mom. And he's now uh, still living with my dad. He's high functioning, but he still and will need services for the rest of his life. And I just think programs like this are just phenomenal for families. Um, we can't undo what happened, but I believe that if she would have had the support early on, maybe things would have been different for him and for my family. So when I tell you about the emotional weight, I get it. Um, it can be a lot. I get it. So back to the SNTs, I want you to think of them as one part of the puzzle, one part of the ecosystem, all things going together. Because a lot of people get confused on why do I need this if I have this, if I have this, if I have this. And all of the thises means, yes, you need to have them all because it's part of an ecosystem, right? It's not just a special needs trust that's going to hold the bucket of money for your child. It's your own will, your own trust, especially if you have other children that are not special needs or you're a blended family. What happens? How are the assets divided for everybody else before a part or all of it goes to the special needs, right? So a will is just a set of instructions for a judge. That's all it is. That's it. It's very simple. It's a set of instructions for the judge. A trust, think of it like a privatized set of instructions for your trustee. A will requires a judge to look at it, give it validity, and determine how your assets are going to be executed in probate court. Because it's a set of instructions for the judge, we are automatically going to probate court. A trust protects your assets from probate court because you've already put things into the trust. There's no need for a court ruling to transfer property from this person to that person because you've already put everything into that trust. So there's no need. The trustee takes the keys and administers it according to your wishes. But if done correctly and funded correctly, your family doesn't need to go to probate court. So this is important because of how time consuming, how emotionally draining any kind of court proceeding is. But if we can avoid it and make things easier and streamlined for every family, especially families with children with special needs, we already are dealing with enough. We don't need to add on more complexities to stuff. So it works as an ecosystem. You need your own will, your own trust, and a special needs trust just specifically for that child who will require it. The powers of attorney are very important. These are powers of attorney for yourself, right? One is financial, meaning if I'm incapacitated, I'm still alive, but I'm incapacitated to the point where I can't make decisions for myself. This person can act as my agent and help me administer day-to-day things. It could be short term, like I get COVID and I'm in the hospital, or long term, like I have dementia, right? It could be the whole span. And then there's medical powers of attorney, which everyone here, I'm sure you've all heard of, which is the same analogy. If I'm incapacitated, who makes medical decisions for me? But the separate powers of attorney that we need to think about, in some cases we can, in these planning for families, right, is powers of attorney for your child. So if they have the capacity, can we get them at 18 to give a power of attorney so that you can help them continue navigating the very complex medical system? And if they're not, then what is the plan for going to court and getting a full or limited should guardianship uh, for them, meaning because they're 18, even though they have special needs, they're 18, which means they are considered legally they're an adult. So if they can't have the capacity to sign over a power of attorney, you got to go to court, get a limited guardianship so that the court can specify, yes, you as mom, dad, auntie, caregiver can help them handle daily financial decisions. For some families, the capacity is so grave that it may be a full guardianship capacity. So again, the SNT is not the end of all be all. It is part of all systems working together, making sure that we have a will, which by the way, that's where you designate who is the guardian of your minor child. You can't do that when they're 18. Got to go to court for probate. Your trust, your powers of attorney, and then considering where is my child? Are they going to need? Am I going to have to prepare for a limited or full guardianship proceeding in probate court? So my advice on that is don't wait. Talk to people that have done it before, get expert advice. And if you're in that range of, you kind of have a 16, 17-year-old, start early so that you have that in place or you know what you're going to do. You're not at the 18 birthday mark. Oh, shoot, we never got this done. And now legally they're 18 years old. I say that to my families who have college students too that go away. If they go away to college and they're 18 and they get in a car accident, God forbid, yeah, to the hospital, that is your baby, but they're also 18 years old. And without a HIPAA waiver, hospital doesn't have to give you access to any of their medical records or allow you to make any decisions. Same thing. You don't have these things in place, court has to put them in place. And that's exponentially difficult. So we can avoid that by making sure that we just cover our bases. Okay. How do I pick a caregiver, Yvette? How do I pick a trustee? How do I know, right? A lot of people think, well, it's going to be my family member, and sometimes I have to tell them the most loving choice that you can make isn't necessarily going to be the obvious one, right? Isn't just your oldest child because they're old, they're the first one to turn 18 and they've done it, so they can take over. Not necessarily. You want to think about the what I call, the key qualities of that person. So they're are they how responsible are they? What is their long-term availability? Maybe it is older brother, but maybe older brother likes to party. Maybe older brother is going to be getting deployed and overseas, right? Maybe they're just not going to be available. They could be the most responsible, but maybe they're just not going to be available or have the mindset to do it. Are they comfortable with benefit rules, right? Are they comfortable navigating that whole system of Medi-Cal and IHSS and SSI and the region? Like, how comfortable are they doing that? Um, it's a lot. It's a lot, and it's something to really think about over a series of meetings sometimes that I have with my families. It's a lot to think about. Sometimes co-trustees or professional trustees are the better answer when it comes to managing funds specifically. Um, my job is to look at this holistically. How can we avoid fights and all of that? So that's a really key component. Another key component is a meaningful letter of intent. I can put all the financial and legal stuff in place, but at the end of the day, you're the caregiver. You know exactly your child's routine, their providers, their triggers, their comfort, what brings them joy, their hopes, their values. This is where your voice is stated so that somebody can read it when you're not no longer there. This is crucial. It's not a legal document, but it is crucial for the next person picking up after you to know and kind of make their journey a little bit easier and make your child's journey a little bit easier with all of that in place, all of those tips. So this is a big part of the time we spend with our families too, is making sure that all of that is in there. And of course, it changes, right? This is not it's not a stagnant document. It changes as your child grows and different medical histories, but it's very crucial. It's a crucial document. Add that to the ecosystem that I mentioned, right? So almost done. I want to talk a little bit about mistakes, good intentions, but let's not focus on the good intentions. We want to focus on, again, the ecosystem needs to work, right? We want to make sure things are drafted correctly and we're taking maximum advantage for your child, right? Number one, common mistake, don't leave your child as a direct beneficiary, whether they're special needs or not. Just don't do it ever. Because if they're under the age of 18, they cannot inherit. And so mom, dad, whoever's caring for that child after you're gone has to go to court and petition for a limited guardianship so that they can go cash that check, that life insurance check, whatever it is, because you've left it as a direct beneficiary. So if there's no will and no one's left as a guardian for that child's estate, we're gonna have to go to court, and it's crazy expensive, and long. Takes very long. Here in San Diego, we're looking at those petitions at least 5, 9 months out. In the meantime, the check isn't cashed. So the DIY, right? DIY or you see the templates online. Be careful. Have those things reviewed by a professional. What you'll find a lot of times is that company or that DIY provider, they will name themselves as trustee and put their trustee compensation, um, not beneficiary, compensation to manage the trust after. So, that saying that says it's not too good to be true, right? It's well intended. They could be good documents, but not too good to be free. There is a cost, there's always a cost. So you get a lot of times uh who sign up for a lot more than you bargained for by thinking I'm just going to go to the free site or the discounted site. Be very, very careful. Um, Same thing as leaving money to siblings to manage. They'll do it. I have faith in them, right? I hear that all the time. You never know. You never know. And now, if they're not in a trustee capacity, they have no fiduciary duty. That money is 100% legally theirs, and they don't have to do what you told them, I want you to do with the money. If it's not in the trust, if it's not in the will, it didn't happen. It's your word against theirs, and that money is 100% theirs. That could lead to tax implications and gift implications on federal taxes that they might not want. But again, think about also just the family dynamics. If I left this one child and they're going to handle it all, how that looks and the implications, it's just messy. It's messy and it's prime for conflict. UTMA accounts, right? There's nothing inherently wrong with UTMA accounts, Uniform Transfer to Minors Act account. That's what that means for. It's a simple bank investment held in your child's name that you are the custodian until that child's either 18 or 21. The problem is that, guess what? It's subject to the income limits, the asset limits, and you can't control it. So once they reach 18 or 21 and they go pull it out, you've lost control, right? And it could be devastating. There are people that pry on our vulnerable population, young adults, that have just enough access. And guess what? Now the money is gone because some person on YouTube or some media told them to let them borrow money, and it's a scam, right? So they pry. You really do pry on our vulnerable folks. And ignoring legal help, right? You're here today. Hopefully this resonates with you. Don't ignore what I'm telling you. And then the pooled S&Ts, right? The pooled special needs trusts. These are basically community accounts where your child's money is there. The benefit to that is, yes, it's protected. It's away from the, income test, but you give up control, a lot of control, including what happens again after if your child passes away, who gets it? Oftentimes, that nonprofit, that charity, that pool, they get it. They're the beneficiary at the end of the life. So be very, very careful. A lot of families use this. And again, there's nothing inherently wrong with it, but as a financial educator, I can give you some really good other things to think about to make small investments and make sure that you retain control and you still do right for your child. So those are not my favorites. Okay, so almost done wrapping it up here. Why it matters, why planning with a professional matters. Obviously, we do this day in, day out. But with somebody like me that has a personal story that understands the emotional weight, that's important. You want to make sure that whoever you're working with, you have a relationship with. And that's one thing that I tell my families that's really, really important is will this professional be there, 5, 10 years when my child's needs might change, right? Are they on top of the law? Do they understand, right? All of that expertise is good. But I want you to also think about the importance of some financial considerations, right? The estimated cost of raising a child with special needs is $70,000 a year. 70,000 over a lifetime, that's 1.5 to 2.4 million dollars just for the care of that one child. It's a lot. So it's not just the legal documents, it's the ecosystem. It's all of that, right? It's making sure that who you're going to understands and can help you navigate and plan for all of that as best we can, right? So my firm, I look at this as a strategic partnership. I do have services that are, you just need to call our office and you just need, hey, Ivette, sit down with me for an hour, help me walk through this one thing. Great. If you need a whole package, we have those, and we offer payment plans because I understand that not every family has the means to just get started all at once. We offer payment plans, monthly installments to make it easy on my families that we work with. Special needs families, why do they? Because you're here today, right? Because you can't afford not to, right? You're here, hopefully you traded in the fear for some action steps. You're building peace of mind and you know that you're not doing it alone. And with that, I'll say this book that we have really sets apart a chapter in this chapter called Val. It's the How Many Works book for women. It's back here. You can see it. But it brings this chapter to your niche. It lets the public know broadly, like, hey, these families, there's a lot of us, right? 1 in 5 children have a special healthcare need. That's 14 million children, over 14 million children, right? And I told you already how much it costs roughly. We also know that most people that have a disability in 2020, I think it was 2021, the statistic, were not holding a full-time job or a job. So Val, this character here, she is a social media influencer. Her son's been diagnosed with autism. She had to change careers, and she's mostly concerned with like, how do I plan for my son, but how do I also plan for me? How do I plan for both simultaneously? So love this book, the chapter just for you guys that I think you'll really like. So what can you do today? So today, what, Yvette, what can I do? Right? Do do this, right? Review the beneficiary designations. Do I have my child as my primary, secondary beneficiary? If you do, stop it. Stop naming them directly. Talk to your family members, right? You probably already have that. Maybe dive a little bit deeper on the conversation. Hey, are you still okay with me putting you as their guardian on the will, or I'm thinking about doing this step? Can I put you down? Where are they? And get really intentional about asking several people so you have one, two, three backups um, for your plan, for your family, right? Start that letter of intent. Doesn't matter if you don't have the other things in place, start that. Because if something happens to you or you want to go on vacation or something, that whoever's caring for your child needs to know what do they like, their medications, all of that. And you may think you have it organized on post-its all over stuff. You might think so, but maybe you don't. Maybe you could organize it better. So starting that letter of intent is a really good thing to kind of start giving you some peace of mind. Um, Call my office, get a copy of that book from me, right? Yvette, how do we get a copy of that book? Call us and we'd be happy to get you on track to get that. And schedule a planning consultation, whether it's with me or one of the other people that do this. Get some clarity. Sit down with somebody and say, here's where I'm at. What do I need to do? Um, Help me get there, right? What am I missing? Maybe you've done this already. Great. Have it reviewed. Is it updated, right? A trust, an estate plan is not like something that you buy a car, right? And you never put gas in it. You got to keep it maintained. You got to make sure that it's going to be running adequately. Is it funded correctly? Did we transfer everything in, right? Do we have things aside that can fund that special needs trust for your child well after you're gone, right? Is there going to be enough money in there? These are the types of things that we talk about in my consultation, making sure that we dive really deep to the point where you say, okay, I need to maybe do some more. I hadn't thought about that. Good. Because the time to think about these things is now, not later when somebody else has to. It's now. All right. Lastly, to close out, stay in touch with us. I think, Kristen, you're going to put my social media handle on the stuff so you can share that. We do have a webinar coming up on January 22nd. You can come to that. If you need to start, update, or get your stuff updated, the QR code is there.